Hello everyone. This week you're dealing with freedom of expression, and I thought that it would be very useful for you to have a little bit of um, verbal, oral explanation connected to the reading and the slides when it comes to freedom of press, and an additional issue related to equality, equal human dignity, and hate speech. And so I thought it's important when it comes to freedom of press and the cases that I put on the slides, because based on my previous experiences in classroom conversations, it became obvious that it's kind of difficult to get the logic of the application submitted to the Strasbourg Court with regard to Article 10 of the Convention, and how the decision is made, and how the arguments are done, and when, where, how a violation of the convention is found. So if you take this example on slide number 7, Tammer versus Estonia, this case, then through this case I explain to you the logic behind the application of Article 10 in the case of cases of press as applicants. So in this case, basically you have as an applicant a representative of the press. In this case, this gentleman, Mr. Tammer, was a journalist who published certain articles on this assistant, this lady, this assistant of the Minister of Internal Affairs. And the whole article was about her private life, pretty much. And the article was kind of defamatory, so kind of undermining her reputation. And there was nothing in the article about public affairs or how the lady is performing her functions as the assistant to the Minister of Internal Affairs. So the journal got fined for this article, and that's the reason why the journalists turned to the Strasbourg court to claim that freedom of press, freedom of expression, thereby Article 10 of the Convention was violated by Estonia because of this fine. And so since the court found in this case, pretty much in an understandable and correct way, that the whole article was focused on the private life of the lady and not her public activities. So there was no issue raised in the article which would have been of public concern. Because of that, the fine was legitimate. So the state's reaction on this article was absolutely in compliance with the European Convention and its Article 10. And because of that, the fine itself did not mean that it's a violation of Article 10 and freedom of expression, freedom of the press. I guess now you get the logic. It's not too complicated, but somehow in classroom conversations, we always ended up with certain kind of confusion about, yeah, but shouldn't there be a violation of Article 10 if the article was defamatory? Of course not, because this is about the assessment of the state authorities' action and whether they act in non-compliance with the European Convention. Okay, so in that case, you had a public official, but you had an article with which focused on the private aspect of the life of that public official and not the activities that were of public concern. So whenever it's about a public official, and the article or any kind of publication of the media is focused on the activities of the public official, which is of public concern, then public officials should display a greater degree of tolerance when it comes to criticism. Why? Because the Strasbourg court itself, and you will see little extracts from the relevant Strasbourg judgments, that the court puts high emphasis on the significance of the work of the press in a democratic society. and especially when it's about debates, public debates about whether a public official is performing his or her functions appropriately. That's very important for a balanced dialogue, a balanced dispute in a democratic society, and that should be protected by Article 10 of the Convention under the aspect of the right of the public to get public information or information on public affairs. And so here, the press and the media organs have a greater space, a broader space for expressing all kinds of value judgments. And it's very important here to distinguish between facts and statements on facts and value judgments and opinions. So when it comes to the facts, obviously, press can be fined and can be sanctioned for bad faith publication of untrue facts. And that can be proven in a court of law. But when it comes to value judgments based on information gained by tools of the media, and it's far from an evidentiary procedure of a court of law, then the assessment should be kept in a more flexible way. So broader space should be provided for the press. So in these cases, the test is rather based on good faith and whether the press had good faith while assessing the gained information, instead of like stringent, severe, strict truth proof. And so for untrue facts published by the press, again, the press can be sued successfully in the court of law, while when it comes to value judgments, there should be only a sufficient factual basis for the value judgments. And that's what you see in Lingens versus Austria, when it came to the critical remarks on the Austrian Chancellor, and there you see again this standard that public officials should tolerate even very strong criticism coming from the press, and that kind of language, the critical tone, can be extreme as well and very provocative. You see that in the next case too, Torgersen versus Iceland, when it came to the criticism related to allegations about widespread ill treatment conducted by the police, where very strong language was used, beasts in uniform. That's how they qualified the police. And of course, there is an interest, a public interest, connected to the need to protect the reputation of the police. It's very important to maintain the trust of citizens invested in the police. At the same time, it's also very important to reveal any kind of ill treatment, since the police has a very strong power to use force against citizens. So there is also a public need, a public interest connected to the protection of physical integrity and the life of citizens, as opposed to police brutality. So there's a public interest there to have a healthy debate and open debate about potential brutality or treatment of the police. And so that's a very important public affair. And here you see that here we don't have a specific person as a public official being subject of the articles published by the press, but instead we have a state authority which the press is focused on, and the very important public affair that is discussed by the relevant or the respective articles and media reports. So there you see that the same standards apply both to the criticism of public officials by the press and the discussion of public affairs. And in both cases, these extreme strong terms can be used. Why? Because the media needs to provoke citizens, draw the attention of the citizens to these significant issues of public concerns. And because of that, the media has this tool of using provocative and extremely critical language. So it shouldn't be restricted, the right to use this kind of provocative language either. So now I managed to emphasize certain key points when it comes to freedom of press, and I hope that I managed to explain to you certain potentially unclear points on the relevant slides. And now I would draw your attention briefly to this hate speech issue and any kind of dissemination of information and dissemination of racist ideology and discriminatory ideology, and coupled with that kind of incitement to hatred. When it comes to hate speech and racist speech, and all kinds of speeches related to the Holocaust, for example, and the superiority of certain social groups, then the court is very strict in protecting the basic values that were key values at the very establishment of the Council of Europe itself. You know that from your previous studies in this course itself, that the whole basis of the establishment of the court and of the Council of Europe itself, the organizational framework of the whole court and the European Convention, was the experiences, the tragic experiences of the Second World War and the Holocaust. So whenever it comes to the Holocaust and Nazism and the dissemination of Nazi ideology, then the court is very rejective when it comes to incoming applications. So you see here two cases. First case is the Kühnen versus Germany, where we have this well-known leader of an old extremist organization which advocated for the revival of National Socialism in Germany, and promoted all kinds of ideas related to racial pride and superiority of the white race. And he turned to the Strasbourg court arguing that his freedom of expression was violated by the conviction of the German courts. And the court refused even to go into the merits of the case. So the complaint itself, the application itself, was found inadmissible by the court and rejected in the very initial phase of the procedure. Why? And you see there a brief explanation on slide number 17, that the convention prohibits any activity aimed at the destruction of any of the rights and freedoms set forth herein. So basically here, these ideology and this information that and views that the applicant was disseminating, they were basically aimed at undermining the core value system and the basic order of freedom and democracy that the whole Strasbourg system is based on. It's clearly understandable, and since it's like a very frontal attack against the very key value of equal human dignity, it's an acceptable, under my understanding, it's an acceptable approach and the pretty much supportable approach of the court. However, it's very interesting when it comes to Holocaust denial cases, and genocide denial cases, to be very precise. And you see here this case, DI versus Germany, which is about David Irving, this historian who denied the existence of gas chambers in all kinds of academic publications, and he was fined in Germany. All kinds of other parallel procedures were ongoing against him, like a libel suit in the UK against Deborah Lipstadt, who refused publication and who pretty much counter spoke against the ideas of David Irving, and claimed that he's not a historian, he's not a real historian, because this is ridiculous to deny the existence of the Holocaust and gas chambers. Actually, you see here on this slide number 18, a poster of a movie, which I recommend to you, The Denial, with Rachel Weisz, for example. She's playing Deborah Lipstadt. It's a pretty credible movie, and it's not at the same time, it's not a documentary, so it's enjoyable. Whenever you have free time and you're interested in this topic, then I recommend this movie to you. So, because of the fines imposed on Irving in Germany, he turned to the Strasbourg court. And of course, the court found the complaint again inadmissible, so rejected this application in the very beginning of the procedure, saying that the court is not open for dealing with the rejection of clearly established historical facts, and the whole views promoted by Irving goes against the basic principles of peace and justice, which are the main purposes of the European Convention expressed in the preamble itself. And that Irving has advocated for racial and religious discrimination. Now, it's very interesting to compare this case with another case, Perinček versus Switzerland, which was concerned of the Armenian genocide. So not the Holocaust, but the Armenian genocide. This case even went up to the Grand Chamber of the European Court. And the whole case was about the Swiss court's conviction. The Swiss court convicted Perinček for the denial of the Armenian genocide. And in this case, the Grand Chamber didn't come up with such a reasoning that there are clearly established historical facts which were denied, and because of that, the application of Perinček is inadmissible. But actually, the court said that the Perinček's application was well-grounded, and that by his statements there was no incitement to hatred towards the victims of the Armenian genocide, and thereby there was a violation of Article 10 of the European Convention. So it's very interesting that here the court had an absolute different approach than that applied in the case of the Holocaust. If you're interested in that, it's worth to look into the dissenting opinion connected to the Grand Chamber's majority opinion in the judgment, because there you see opposing views coming from the judges who think that there should be a similar approach as applied in the case of VI versus Germany and as to the Holocaust. Thank you for your attention, and good luck with studying about the freedom of expression.